What if Cheech and Chong want to move into your rental property? I'm assuming you want to know what the law says about marijuana and your property. On November 8th, California passed Prop 64, which legalized recreational use of marijuana for adults 21 and older in a home or business licensed for on-site marijuana consumption. It's illegal while driving a vehicle and in public places. Smoking marijuana is also prohibited in any place where tobacco smoking is prohibited by law. Possession of up to 28.5 grams of marijuana or 8 grams of concentrate is legal, but not on the grounds of a school, daycare center, or a youth center while children are present. It's legal to grow up to 6 plants in a private home as long as the area is locked and not visible from a public place. What about medical marijuana laws? Because the Compassionate Use Act does not give medical marijuana patients an unrestricted right to grow, possess, or use marijuana, property owners are not mandated to allow marijuana use on their property simply because a resident has a medical marijuana card. What about federal law? Marijuana use, cultivation, and distribution, both recreational and medicinal, are still illegal under federal law. In 2005, in Gonzalez versus Wright, the U.S. Supreme Court said that Congress has the authority to prohibit local growing and use of marijuana, even if it is allowed by state law, so compliance with California's law is not necessarily a defense to a federal marijuana-related crime. The Obama administration Justice Department issued a memo called Deprioritizing Prosecution of People Who Are in Compliance with State and Local Laws. That got repealed by the Trump administration, and this means federal prosecutors can go after recreational and medicinal users and growers, even in states where these activities are illegal. So can you as a property owner prohibit the use and cultivation of marijuana on your property? Yes. The law specifically allows owners of private property to prohibit any of the actions related to marijuana that are allowed by the initiative. What if a tenant is disabled and wants to use or grow marijuana as a reasonable accommodation for a disability? If this happens, I would recommend the owner contact an experienced fair housing attorney to determine an appropriate response, but there is legal opinion that because marijuana is prohibited by federal law, it can't be considered a reasonable accommodation. So if Cheech and Chong do move into your rental property, now you know your options. Thanks.